Now, as you know, yesterday the Privy Council ruled against the government's decision to extend local government elections and the life of councillors and aldermen by 1 year. This was a decision 3-2 to the Privy Council ruling against the government. I'm now joined by Opposition Senator Jayanti Lutchmedial to discuss the Privy Council's ruling. She's with us via telephone call this morning. Good morning, Opposition Senator.
Hi, good morning. How are you?
Fine, thanks. Thank you for joining me. On what grounds was the Privy Council, the three lords of the Privy Council versus the two, were they unable to agree with the decision of the Trinidad and Tobago's Court of Appeal?
Well, basically, there were two limbs to this argument, and the limb that they agreed with is that by way of what we call the retrospective application of proclaimed legislation, what the government essentially did is delay an election and make a new provision in the law, an amended provision, applicable to persons elected in 2019. And we argue that is what you call retrospective application, which ought not to be done. There's some excellent learning in this judgment about, I thought it was particularly instructive that the Privy Council said that the right to vote out is as important as the right to vote in, and that they could not glean from the amended words that the intention of Parliament, because at the end of the day, remember, it's not the government alone that makes a law, it's the Parliament. So all of the parliamentarians who voted in support of this amended provision whereby the term of office was changed from 3 to 4 years, they could not gather from the wording of the legislation and any of the evidence before them that the intention of Parliament was to make that provision applicable to the existing councillors and aldermen elected in 2019. And they said in the absence of clear and express provisions to that effect, it would not be for the Parliament or even the government to tinker with, the term of office of elected representatives. Mm-hmm. And that's the simplest that I could put it, basically.
So basically, the three lords of the Privy Council took issue with the fact that government, by extension Parliament, actually having the power to decide the life of local government representatives.
Well, exactly, and that's what they did. You see, 1 month before the election was due, they took a decision to proclaim this one section, and that one section dealt with the term of office, which, and I would say as someone who voted on this bill and who contributed to the debate on this bill, it was never in our contemplation, at least as the opposition, that extended period of time was applicable to the existing representatives. It was always in our mind understood that when another election took place and all of the reforms were put in, that the elected representatives would serve for a period of 4 years. I would say this too, that we also had in front of us when we were debating this bill a series of changes to the structure of local government. So the persons who are elected at the next election would not be functioning in the same way as the persons who were elected in 2019. And that, in our view, is a fundamental part of the argument, because you cannot say that suddenly, it's almost like today you're a television host, and tomorrow I say, well, I've proclaimed a law which means that you're no longer a television host. You are now, the tea lady at WESN. And we've proclaimed the law mid your term, and we've extended for another year, but you're the tea lady for the last year of your term, when you thought your term as a TV producer was going to end in next month. Like that, that's how ridiculous it is. The entire role, function, duties, and responsibilities of local government representatives will be changed when this law is fully proclaimed and implemented. So how could you then say, well, just giving you the extra year now when, you have a different role? They haven't proclaimed the other parts of the law that deal with the different rules. So listen, this was nothing more, in our view, than an attempt by the government to avoid facing the electorate. And it was a real, what I would call a legislative sleight of hand. That, one of the things that the Court of Appeal, one of the judges at the Court of Appeal raised with us is that, look, it's open to parliamentarians to ask that specific clauses be put in dealing with the time of proclamation and so on when you're dealing with legislative matters. And that may be something that the opposition going forward would have to take into account, because never before have we seen a government try to come through the back door and delay elections. I want to point out something which is also very critical in this case. In the past, we had delays to local government elections under the when Prime Minister Manning was in office. And he came, at least, I'm not saying it was right, but he at least came to the Parliament with an express amendment to the Local Municipal Corporations Act to say local government elections will not be held when it is due, it is deferred to this day. And he passed it. Yes, he used his parliamentary majority to pass it, but at least he was open, clear, and forthright with the fact that he was bringing legislation to defer the election because, well, at the time they were also discussing reform, etc., etc., etc. And that was his justification for the deferral. So this, to me, was dishonest on the part of the government. It was a way for them to really defer the election without saying we want to defer the election. But they relied on statutory, it was their version of statutory interpretation to avoid facing the electorate at a time when, as I pointed out, if you go back in the archives, you would see that the time when this election would have been due and councils and all of them would have been demitting office, it would have been the time when, you know, we were approaching that 600 murder mark, the entire country was in an uproar, and so many things were going on. And it's clear that, you know, they did not want to face the electorate at that time. I think they still don't.
Mm-hmm. So let me ask
they
you,
were
you
hoping
keep
to buy time to put things in order.
You keep saying, in our view, just for clarification, are you referring to the legal team, are you referring to the opposition, or is it that both share the same view?
Well, I wear both hats in this case. As you know, our litigant in this matter, Mr. Ravi Balgobin-Maraj, you know, has been a true, I would call him a crusader in terms of taking the government to task. But it is really, you know, under the leadership of Mrs. Kamala Prasad-Bissessar, we, of course, have the support of many people, including Mr. Ravi Balgobin-Maraj, as a litigant, a public interest litigant, to take on these matters. But the opposition, working myself, Mr. Ram Logan, and others, and Mrs. Prasad-Bissessar, you know, really took to studying the intricacies of this case. I think people aren't aware of how much research and thought and strategizing and analysis goes into the process of bringing a claim before the court to challenge a public law decision. It is a lot of work. Mm-hmm. So the opposition works very closely with, and I think that's why Mrs. Prasad-Bissessar always refers to, well, myself, Mr. Ram Logan, and others, our legal team, our lawyers.
Let me ask you,
they do basically fulfill the role to some extent as a you know, a supporting entity. And this particularly because it dealt with legislation, the UNC, our MPs, our local government practitioners were also very critical and offered a tremendous amount of support.
Well, Senator, did the law lords at the Privy Council, did they speak about the language as stated in the Miscellaneous Provisions Local Government Reform Act? Did they criticize any of the language?
They said that, yeah, they actually read the amended provision, parts of sections 11 and 12 of the Municipal Corporations Act. And in their judgment, they stated, like, for example, the term the term shall be 4 years. To them, they did say that language appeared to be prospective in nature and to apply to persons who would be coming into office. And that was always our argument. And I'm being quite frank with you, we also argued another point, which I think the government is trying to hold on to for salvation, which we did not win on, which is that the constitutional, we have a specific constitutional right in Trinidad that is unlike any other Commonwealth constitution. Again, most people know this, but that was actually a negotiated specific right that was placed into our constitution by the then opposition asking for it, Mr. Capildeo and others, wanting the specific right of freedom of political expression. So everyone has a freedom of expression, and we have freedom of expression, but we also have a separate specific right of freedom of political expression. And we try to argue that by deferring elections, you were taking away people's right to freedom of political expression, because the ultimate manner in which the ultimate way that you express your political view is through voting. You understand? But we were not successful on that ground simply because local government elections are not part of our constitution. And the opposition has raised in the past when we're discussing local government reform that we think it is important to consider putting local government in the constitution because local government is becoming more and more important.
What are your thoughts on
what
are your thoughts on the Attorney General Reginald Moore suggesting that the Privy Council had no issue of interpretation with regards to the breach of constitution or of any common right to vote by the extension of the date for calling local government elections?
Well, I wouldn't say they had no issue with it. They didn't say see it as a constitutional breach. Now, I don't think people understand the difference between constitutional and legal. If you break the law, you do something that's illegal. If you place an interpretation in the law that is wrong, then it's illegal. If you breach the Constitution and a provision of the Constitution, it's unconstitutional. So there was no breach of a provision of the Constitution. But what the government did is they interpreted the Municipal Corporations Act in a way that could not be upheld, and that's why they lost. So it's not that there was nothing illegal. It was an illegal interpretation. It was an interpretation that was give retrospective effect, and it wasn't permissible. So I looked at a press conference yesterday, and I saw that as a very, I felt sorry to some extent. I thought it was pathetic. I thought it was a real last-ditch effort to save a little bit of face. What I found atrocious was the comments about warning the media about reporting on the matter and that they could possibly find themselves in contempt. That is really desperation at its highest. When you think the PLM cannot stoop any lower, they surprise you because what they are really trying to do is take control of the narrative in this matter and stifle public debate. And again, they are showing their frank and open commitment to just taking away our democracy and our rights. If it's not freedom of the press, it's freedom of expression or whatever other freedom. You imposed. That's what the Privy Council basically said. You imposed, the government imposed the representation on people that they did not vote for. And then you are turning around now to say, well, be very careful how you report this matter. You will find yourself in contempt. I mean, that's ridiculous.
The AG pointed out the fact that it was 3 lords of the Privy Council versus 2, and the ruling still of the appeal court in Trinidad is relevant. Are there any concerns in the fact that it was 3 versus 2? It was a slim, in other words, just one individual who would have made the entire difference in this vote. So,
I don't know, you're probably familiar with the judgment of Surat and Barry Francis that the government likes to talk about all the time. That was Barry Francis, coming out of our Court of Appeal, was also a 3-2 decision. And the 2 judges who dissented in that case was our Chief Justice and one of the most distinguished judges in the region right now, Justice Jamada. It matters not. The law is, and this is the doctrine that we followed from time immemorial, is that the majority decision is what binds. And the Privy Council binds the Court of Appeal, and the Court of Appeal are now bound to follow the decision of the Privy Council. So you can't add 3 from the Court of Appeal with your 2 from the Privy Council and try to manufacture something that looks like a win to save face. It doesn't work that way. The judgment of the Court of Appeal was overturned by the Privy Council, full stop. That's the end of it. That's the decision, and this is what binds the government and the entire country right now.
If it is up to the government now, or by extension the Prime Minister, to call a date for local government elections, even following this ruling, does the Prime Minister still have the power to call local government elections in December of this year?
No. Quite frankly, I don't think so, unless they come up with some other creative legislative sleight of hand or turn, or they come back to the Parliament and basically come and say, look, we need to put this off again and defer it in the way Mr. Manning did. And if that is the case and that is what they choose to do, well, they will answer to the Parliament and they will answer to the population. You cannot continuously find creative loophole ways, which is what they did in this case, to avoid facing the electorate. If you're not ready and you know that you are in a position where you cannot face the population, you cannot face the electorate for whatever reason, well, come out and say so and say, listen, I'm bringing a specific provision to defer election, and you will pay the political price, and you will answer for your political decisions, because that's what it is. It's a political decision. And what they try to do in this case is mask a political decision with by sanitizing it as though it was a statutory interpretation issue. But it was a political decision. So if you have a political decision to make, come out and play man and say that it's a political decision that you have to make.
But the decision does not give a set timeline for when elections should be called. That's one of the concerns, because the opposition leader called for elections to be called now, but...
Right. What the decision says is that the amendment did not apply, which means that elections, councillors and aldermen were supposed to dismiss office on the 3rd of September, and once they dismiss office, the way the provision is read, if you read the entire provision, there is a time frame in which the election ought to be called. That is about 3 months. It's 3 months from the day that they dismiss office. So we are well outside the time in which the election ought to be called. The election is due, and if they fail to do it without some sort of statutory legislative approval from the Parliament, well, I'm sorry, but I guess I'll just have some more work to do.
Well, Senator, thank you very much for joining me this morning. I think there is a lot to work to be done, because I don't think any political party at this point in time is prepared for local government elections. We have to bear that in mind.
Oh, that's not true.
Yeah.
That's not true at all.
A call for representatives from all ends of the political spectrum.
Yeah. Well, we reopened our nominations, but I want to point out something. The UNC, and again, this speaks to the mindset of the people who were debating this law and how we interpreted the law. We last year opened our nominations. We had our nominations open. We closed nominations. We had all persons interested last year filing nominations. We have reopened given the lapse of time, because some persons have now expressed an interest in stepping forward and serving. So we have reopened for a very short period, for 1 week. But it shows you that we never thought that this amendment could be applied to the existing councils and aldermen. So we were, since last year, had our ball rolling in terms of receiving our nominations, and we were ready to start screening when the government dropped this bombshell that their very creative way of avoiding the electorate come December. So I don't think it's fair to say that nobody is ready. We have started the ball rolling, but of course, they derailed the entire process, and we now have to get back on track, and it is for them to get the country back on track. They cannot continue to just rule by way of, autocracy, and that's what they're doing.
Mm-hmm. Well, Senator, thank you very much for your time this morning and for sharing that information with us. And we look forward to the response on the part of the Prime Minister, because I know the Attorney General has responded. Let's hear what date local government elections are set for, unless, as you mentioned, some special legislation is now brought to the Parliament. But for now, thank you very much and have a great day.
You too. Bye-bye.
Bye-bye.